57 seconds.
We're going to call Clayton quickly. Clayton, I'm going to be lightning fast. State your name to the court.
Clayton Echard.
Did you participate and sign the pretrial statement that we provided to Judge Monta?
Yes.
Are those statements true and accurate?
Yes.
Are we asking the court, in light of our very limited time today, to consider our pretrial statement as part of your testimony today?
Yes.
How did you meet Laura?
Laura targeted me on LinkedIn. She asked to do real estate. We ended up exchanging contact info. She became flirtatious, sent me a provocative photo. I told her to come over, and then we saw homes the next day.
Did you have sex with Laura?
Absolutely not. I've said time and time again, she performed oral on me twice. That's it.
Have you heard two other versions about what happened?
Absolutely. Many versions. She's claimed that she was raped by me. She also claims I was too high to remember what happened that day.
I'm going to repeat what you just said. She claimed she was raped by you and that you were too high to remember.
That's correct.
Were you too high to remember?
Well, that's incorrect. I remember every single thing from that night.
Did you rape her?
I did not.
You stated that she gave you oral sex twice that evening. Is that correct?
That's correct.
Where did you complete?
Her mouth both times.
What happened the second time?
She ran straight to the bathroom.
Were your fluids ever down there, as Laura has claimed?
No.
What happened the next days?
The next day, we went and saw houses. I told her that I crossed the professional boundary. I told her that that was a one-time thing. It would not happen again. She became very agitated at that point, was crying, and asked for me to give her a chance.
But hang on for a second. She came over to your house. She gave you oral sex twice. The next day, you told her you weren't interested in her?
That's correct. I rejected her, yes.
And then 4 days later, what happened?
4 days later, she started making claims that she could possibly be pregnant.
But hang on. Did your penis ever go inside her accidentally, inadvertently, or anything like that?
No.
You're a public figure. You're the Bachelor. That's why everyone's watching today. Are you embarrassed to say who you've had sex with, Clayton?
I think I'm the last person to lie about who I've been intimate with.
Did you have penile vaginal sex whatsoever?
No, absolutely not.
Has that been your story since day one?
My story's been consistent since day one.
I'm going to show you exhibit number 3. Put that up on the screen. Thanks, Isabel. Did Laura start communicating with you more after she said she thought she was pregnant at 4 days?
Yes, nonstop. She sent me over 500 emails and text messages, 13 different phone numbers.
13 phone numbers?
Phone numbers.
How many messages?
Over 500.
Exhibit 3, is that a sample of those texts and emails that were shown to Judge Gail Ketzis in the injunction against harassment hearing from November 2nd, 2023?
Yes.
Move to admit exhibit 3, and Judge, you already took notice because you watched the videos.
I assume no objection.
No objection.
B3 is received.
At some point, did she start calling your mom, who's in the courtroom?
She started reaching out to my parents. She started reaching out to my work organizations. She started reaching out to people, women that I talked to in the past. She went for everybody.
Was she claiming anything in particular?
She was claiming that I was a deadbeat that's not supporting her through her pregnancy.
Well, hang on. It was more than that, Clayton. It was a deadbeat who was not supporting her through her pregnancy of what?
With twins.
Twins.
Yes.
Did she reach out to the Sun magazine?
She did, yes.
Did she ever tell you what genders the imagined twins were?
A boy and a girl.
Did she ever tell you, drawing your attention to some motions Laura filed, and for purposes of attorney's fees, she filed a motion to communicate on August 8th, a motion to compel communication on August 23rd, and August 29th, a few days later, an expedited motion to communicate. And then shortly thereafter, she filed an order of protection against her, correct?
Yes.
And you're aware that she's filed orders of protection against 2 other individuals seated in the back of the courtroom, correct?
That's correct, yes.
They are on the left.
Yes. Well, my right, but yes. Your left.
Thank you. Greg Gillespie and
Michael Mancini.
I'm going to look at exhibit number 7, Clayton. Is that a true and accurate copy of email communication between you and Laura from July 1st, 2023?
Absolutely, yes.
You received it?
Yes.
And she sent it?
She sent it,
You
yes.
heard her testified with Ms. Arena from my office, or excuse me, with Mr. Gingras, denying that emails exchanged were from her. She seems to be blaming, I guess, Greg Gillespie for faking her emails. Do you remember her testimony?
Yes, she said that, but nothing she says is true.
She's actually sent you emails with videos attached to them, and you've responded back to them,
That's
correct?
correct, yes.
All right. Specifically, exhibit number 7. I think you stated that it was a true and accurate copy. I think the caption, I'm going to try to read it on the caption at the top. I think it says, "The final opportunity to consider abortion." You remember getting this from Laura?
Yes.
Move to admit exhibit 7.
The objection.
Yeah, no objection, Your Honor.
7's received.
Further down in that email, Clayton, and this will get awkward, but further down in that email from July 1st, which was weeks after the alleged encounter, Laura references her tight vagina. Why is that both uncomfortable and relevant to court today?
Because she's stating that if I would have felt how tight her vagina was, I might change my mind, which is her stating that I never penetrated her. We never had penetrative sex.
Wait, the exhibit that the court just received has Laura saying that her vagina was tight as if you hadn't been in there before?
That is correct.
Well, had you been in there before?
I had not, no.
All right. She also sent you communications in exhibit number 7 talking about wanting to have sex with you during a trial week. What was that about?
Yeah. She said that she would be the safest person to have sex with since she was already pregnant.
But hang on for a second. She told you she wanted to have sex with you because she was already pregnant?
That's correct.
How did you feel when you read that email, Clayton?
I'm sick to my stomach. All of this has made me sick.
Did you feel like she was trying to trap you?
Absolutely.
You heard the testimony with Dr. Medshow concerned that Laura was on IVF medication trying to get pregnant. Is that consistent with those concerns?
Yeah, I believe that she was taking medications.
I'm going to show you exhibit number 6. And let me restate that question. You heard my question to Dr. Medshow about IVF medications, which are used to cause pregnancy, and you share concerns that she was using those to trap you. Is that correct?
Absolutely, yes.
All right. Exhibit number 6, Isabel. Exhibit number 6 is another email dated June 28th, 2023. Is that a true and accurate copy of the correspondence between you and Laura?
This is.
You remember reading this?
I remember reading this.
You remember reading it on June 28th-ish when you received it?
I do, yes.
And the title of this, can you read the title of this out loud for the court?
Having the baby if I don't hear back tonight.
Having the baby if I don't hear back tonight. Move to admit exhibit 6.
Any objection?
No objection.
6 is received.
Thank you. I'm going to show you exhibit 11. Did Laura send you ultrasounds during this time period?
Yes, she did.
Is exhibit 11 an image of an ultrasound you received from Laura?
Yes.
She's going to claim that she didn't send this to you, but how do you know this came from Laura?
Because I was interacting with her from that same email address. I also took a screen record showing that it was from her email address, and that's where all my other communications have come from her.
Real quick, so on exhibit number 11, this one says, the caption on it says ultrasound video proof, correct?
That's correct.
And the signature block on there in the picture is the exact same signature block and picture from the other email, which is also not favorable to Laura, which she claims is not hers, correct?
Yes, no, that's
Move
right.
to admit exhibit 11.
Any objection?
No objection.
On exhibit 11, well, do you know where the video came from on exhibit number 11?
Yeah, from a YouTube video from 7 years ago.
YouTube video from 7 years ago? On that, this is the one that says smile, right?
Yes.
Okay.
Yeah.
This one says GE.
No, this one's a different one. Yes.
Okay, because how many are there? How many ultrasounds have you seen?
3.
Okay. This one, I think on the caption says, and here's my 100 million% real ultrasound.
Yeah, a lot of zeros. Yeah.
You remember? I don't know if my math is right on that. Do you remember receiving that?
Yes, I received it from Laura. Yes.
Court already admitted it. I'm going to show you exhibit number 28. You recall receiving this ultrasound?
Yes, I saw this from Bonnie Platter.
Okay, I'm going to be real clear about this. Miss Owens just testified that she did not use this ultrasound in a court proceeding, but it was actually admitted as an exhibit by Laura through her counsel at the February 2nd, 2024 deposition of you, correct?
Correct.
All right, that video deposition of you, have you seen that recently?
Yes, I have.
Where did you see the video deposition of yourself, Clayton?
It was posted on YouTube by either her counsel or herself.
Wait, Laura or her counsel posted your video deposition on YouTube?
That's correct.
How many paternity tests did you take, Clayton?
3.
I'm going to show you exhibit number 36. You know what? I'm going to skip past that. That was the Dr. Medchill's. I'll skip past that. Well, you know what? Real quickly, how many versions of the HCG test have you seen?
2, I believe. Yeah, the 102 and 100.
One with
2000.
more digits on it?
Yes. Yes.
All right. I'm going to show you exhibit number 46. Would you agree that exhibit number 46 for attorney's fees is a blog from Mr. Gingras where he acknowledges his client faked some of the science tests?
Yes, that's correct.
I'm going to show you, to move this along, exhibit number 55. Exhibit number 55 was right before your March 1st deposition, or right before, excuse me, Laura's March 1st deposition. Actually, did she show up at her earlier deposition?
No, she didn't.
And the court ordered her compelled to attend, and we're still waiting for the court to order on attorney's fees for that. Is that correct?
Correct.
But at her, right before, what happened a day or two related to exhibit 55, a day or two before your deposition?
She threatened to extort me to the tune of $1.4 million in order for me to drop the deposition and the case entirely.
Wait a minute. She sent you a letter a day before trying to get out of the deposition?
Yes, she threatened me.
Threatened you with what?
Monetary means.
Is everything that we talked about today so far, other than the YouTube videos, which are more recent, is everything addressed in prior pleadings already before Judge Mata?
Yes.
Really quickly, for attorney's fees purposes, exhibit number, well, let me get in a few exhibits real quick. Exhibit 29, 37, and 59. These are the medical records from pursuant to subpoena from doctors for Planned Parenthood, Dr. McCool, and Dr. Higley. We moved to admit they've all been considered.
I'm sorry, you said 37?
Correct that, sorry. 29, 37, and 59.
Any objection?
Not to those. Did we talk about exhibit 54 yet?
Hold on 1 second. 29, 37, and what was the other one? Mr.
59.
59 are received. We'll talk about that one after counsel.
And then I'll go back. It was exhibit number 55, which is the letter that Laura sent you, suing you to sue you for $1.4 million before the deposition. Move to admit.
Now that one I'll object to. That's a Rule 408 settlement offer, Your Honor. He's offering to prove that the claim's not valid. That's absolutely inappropriate.
Judge, just
Over objection, the court's going to receive it for the purposes of attorney's fees only. Counsel, you have run out of time.
I'm out of time.
You're at 50. So we can go sit back down. Okay, so counsel, what exhibit were you asking me about? You said has something been moved.
54.
We just cured that.
Okay, all right. I just wanted to make sure. Okay, so at this time, what the court's going to do is I'll take this under advisement. What that means is I'm going to go back. I'm going to review the notes that I took today. I'm going to review the evidence that was admitted to the court, and then everyone will receive my order.
Your Honor, I have one housekeeping matter. I'm leaving the country tonight. I'm not back until June 28th. If the court issues something that requires a quick response, I'm going to be on a boat and I may not have the ability to respond. So I would just ask either that you grant me some extension if I need it. I return back to the country June 28th. So just advising you
Okay, and I'm sorry, counsel, when do you leave?
tonight.
Okay, all right, so June 10th to the 28th, you will
Correct.
be unavailable.
I should have emailed part of the time, but not all of it.
You can't really be held accountable for that, I understand. Anything else administrative?
No, thank you, Judge.
All right, so how this will work now at this point is I have relinquished all security to court security and any underlying law enforcement that are present. They will be escorting people out in the manner that they deem to be appropriate. If there's competing orders against harassment or orders of protection, then we can take those things into consideration. And I just ask that